Police-Induced Confessions 2.0, Risk Factors and Recommendations, Reid Comments. My name is Joseph Buckley, president of John E. Reid and Associates. A number of years ago, actually in 2010, an article entitled Police-Induced Confessions, Risk Factors and Recommendations was published. Recently, a new version of the article was circulated for comments. The updated article is entitled Police-Induced Confessions 2.0, Risk Factors and Recommendations. Unfortunately, from our perspective, it is replete with misinformation about the Reid technique. This PowerPoint presentation will address a number of the erroneous and misleading statements that were made in the article. One of the first statements they make early in the article is, quote, "The Reid technique occurs in two stages. Prior to commencing interrogation, they recommend a pre-interrogation interview aimed at using demeanor and other behavioral cues to detect whether a prospective suspect is lying or telling the truth. The BAI consists of 15 to 20 behavior-provoking questions." Now, that's the name we give to our interview process. It's called the Behavior Analysis Interview, or the BAI. In that statement, the authors completely misrepresented the Reid interview process, which is somewhat ironic because later on in the article, they recommend that investigators adopt what they call a science-based investigative interview. And interestingly enough, the elements that they describe as part of the scientifically based interview are the development of cooperation via rapport and trust, the elicitation of information using productive questioning that enhances a subject's recollection, the use of strategic questioning and assessment of verbal story-based cues to evaluate credibility, and the strategic withholding of evidence as a way to identify statement evidence inconsistencies and resolve a subject's responses to discrepancies. That is exactly what the Reid process is. The Reid process, or BAI, is a non-accusatory, non-confrontational, information-gathering conversation. The investigator is a neutral, objective fact finder. We say at the outset of the interview, it's important, of course, that we meet all of our legal requirements, such as the appropriate advisement of rights, etc. But throughout the interview, we want to maintain that neutral, objective fact-finding demeanor. The investigative interview should consist of three kinds of questions: questions about the subject's background, questions that are specific to the issue under investigation, and behavior-provoking questions. The background questions generally focus on biographical information about the subject: name, age, address, what do most people call them by name, etc. Maybe what they do for a living, where they work, how long they've been there. And then we oftentimes engage in casual conversation about something in the news, maybe one of the games yesterday is part of March Madness, maybe a weather event, this side of town's getting killed with a heavy snowstorm, that kind of thing. And the whole purpose of this dialogue, this early conversation, is to develop rapport with the subject, acclimate them to the interview process, and for the interviewer to get a behavioral baseline of how they normally seem to sit, what kind of eye contact do they maintain, do they use illustrators, how quickly or slowly do they verbally respond, to get kind of a baseline of their behavior. So later on in the interview, when we get to the issue that's under investigation and we see a significant change from what had been their norm, that may have some significance. The investigative questions deal with the issue that is under investigation, the who, what, when, where, why of the issue we're investigating. And in fact, one of the first things our investigators are trained to do is to ask an open-ended question that invites the subject to tell us their story. What happened? What did you see or hear? What were your activities on this particular day? And let them go through their story as to the sequence of events. And we try not to interrupt them at all. Just let them give us what's called the pure version. When they have completed with their opening statement or their pure version, then we will ask a series of questions to develop additional details about what they've said. as well as questions to clarify and develop the who, what, when, where, why, and how of the incident under investigation. During the interview, we'll also try to attempt to resolve or at least address any inconsistencies or contradictions that may have surfaced from the interview of other subjects compared to what our subject is telling us, or maybe a contradiction with the investigative information. If the subject mentions an alibi or where he or she was at the time that's relevant to the investigation, every effort should be made by the investigators to substantiate that alibi. The third type of question that we mix into the interview process are called behavior-provoking questions. These are questions that we've seen over the decades. Most truthful people tend to answer one way. Most deceptive people tend to answer a different way. As an example, these are two questions from a child sex abuse investigation. Here's the think question. John, did you ever just think about engaging in sexual activities with any of the children here at the daycare facility? Answer, I think everyone who works here has thoughts like that. The punishment question. John, what do you think should happen to the kind of staff member who would engage in sexual activities with any of the children here at the facility? Answer, well, I suppose you'd have to look at how many times it happened. The investigative questions are the core of the interview process. As the analogy, that a guy named John was found dead in his home. He had a bullet in his head, found dead Saturday night. John was in real estate, and he worked out of his home real estate office. And he had a couple of colleagues who oftentimes came over and worked out of that same real estate office. So as part of the investigation, they were being interviewed. And we'll call one of the colleagues Dennis. And Dennis was asked in the interview, when was the last time you were over at John's house, either socially or to work out of the real estate office? And he says, oh my gosh, at least a month, maybe 5 or 6 weeks. Unbeknownst to Dennis, the police, when they canvassed the neighborhood, found a lady who'd been out front Saturday morning filming her kids in the yard playing soccer. And she lived across the street from John. And on the film, you could see somebody going up to John's front door, standing there for a minute, and then going into the house. And when they took a closer look at the film, it turned out to be Dennis, who's going into John's house Saturday morning, 10 a.m., the day of the murder. And yet John had lied to us and told us he had not been there for 4, 5, even 6 weeks. That's pretty important, much more important than any behavioral response he might give. At no time during the interview process should there ever be any accusations of guilt. We're neutral, objective fact finders. In our book, Criminal Interrogation Confessions, we devote over 100 pages to conducting the investigative interview. Clearly, the Reid investigative interview process is very obviously much, much more than the disingenuous characterization from this article that it's simply 15 to 20 behavior-provoking questions. Another statement in the article, quote, in the Reid technique, investigators are trained to conduct the BAI, a pre-interrogation interview aimed at determining from a suspect's demeanor whether the suspect is telling the truth or lying, and hence worthy of interrogation. In laboratories all over the world, extensive research has shown that many of the cues that investigators are trained to use, eye contact, changes in posture, emotionality, etc., are not empirically diagnostic of deception, that lay people on average are only 55% accurate, which is like flipping a coin, and that training and experience are not associated with reliable improvements. You have to understand what most of the research studies are. Many of them, if not the majority, are what are called laboratory studies, where a group of students at a university were told that they were going to be guilty people. They're supposed to go into the professor's room, steal money out of the drawer, put it in their pocket, but when they're interviewed over the next couple of days by one of the investigators, they're supposed to deny that they had anything to do with it. And other people, of course, were assigned to be the innocent role. So it was up to the investigator to determine from his or her interviews of these college students who was lying and who was telling the truth. Other studies involved examples of inmates on camera talking about, in 2 different videos, 2 different crimes that they committed. Actually, one is true, they did commit it. One is false, they didn't, but they're saying they did. You as the viewer are supposed to look at these two videos and decide which one is the true crime and which one is the false. None of this parallels what happens in the real world. Think about the inmate study. Once somebody tells us they committed a crime, we're going to ask all kinds of questions to substantiate the details, sequence of events, to probe for information they haven't yielded yet, none of which happened in a study like that. So there's a number of problems with the kinds of studies that they're basing this conclusion on, that behavior is not a helpful indication of potential truthfulness or deception. Number one, most of the subjects of the research, college students, prisoners, or others, really had no consequences. They had nothing that was going to happen to them if they were caught lying or not caught lying or anything like that. There was really nothing at stake. Secondly, most of the investigators were not trained investigators. They didn't have proper interviewing techniques. Probably worked with the researchers to formulate a dozen questions they were going to ask of each candidate. And they may or may not have been appropriate, and they may or may not have had appropriate follow-ups. Many of the studies did not employ the kind of structured interview process that is commonly used in the field. In many studies, if not most, there was no attempt to establish the subject's behavioral baseline so that you could look for any changes from that norm when you got into the topic of the issue under investigation. And most importantly, the research was based on a faulty premise. And the faulty premise was that there are specific behaviors unique to truth or deception. There are no behaviors unique to truth or deception. Just because somebody doesn't look at us when they answer does not mean they're lying. It could be a psychological issue, a cultural issue. They could have been distracted. There could be all kinds of things. So you have to always view behavior in context. Behavior changes the meaning of words. If I said to anyone watching this video, what did you do 7 weeks ago on Saturday? It would be completely reasonable for most of us, if not all of us, to say, I don't know. Obviously, if you look at a calendar and you see the date and something important happened on the date, of course you'll remember. But absent that, none of us would know. So I don't know is a very reasonable answer. If in the investigation of your next door neighbor, I ask you, did you have anything to do last night with causing the death of your neighbor, and you go down, you hesitate, you look down on the towards the desk, and you go, I don't know. We have a different situation. Same words, different context. And finally, in these studies, I shouldn't say finally, and also in these studies, there was no consideration given to the variables that affect a person's behavior that we train investigators to be aware of. Age/maturity, cultural influences, mental capacity, emotional and psychological stability, and the subject's physical condition at the time of the interview, under the influence of drugs or alcohol, not feeling well, having medical problems, etc. Also, in the investigative interviews in the laboratory, they were interviewed in a vacuum. They just had the interview. In the real life world, we're interviewing somebody in the context of an investigation. By the time we're interviewing somebody, the investigation may have already indicated what the relationship was with the victim, what their alibi was at the time of the event, the who, what, when, why of some of the responses that they and their colleagues gave initially. And sometimes there might even be evidence, DNA, eyewitnesses, etc. So we're interviewing the individual in the context of an investigation where there's other information beyond just the interview. In the research studies, it was just the short interview that the investigator had with the subject. So generally speaking, there was a lot of potential problems with trying to assess someone's credibility given those characteristics. And one more consideration that I think might be equal to or as important as any of them is in the real world, we're making a judgment of their possible involvement based on investigative information, information from other subjects, physical evidence, etc. Whereas in the laboratory, it's just the interview. Finally, in the Reid technique, we teach that there are several rules that you have to follow in evaluating behavior. You have to first establish a subject's normal behavioral pattern and then look for changes. You have to read all nonverbal behavior for timing and consistency. If you're interviewing somebody for 20 minutes, almost everyone's going to move or shift their weight or cross a leg or something like that, which in and of itself means nothing. It's when it happens. Does it happen on a repeated basis? Is it in conjunction with a specific issue, question, etc.? You want to look at what's called the overall behavioral pattern, behavioral clusters, not just one thing they do or say at one point. And you always want to evaluate behavior in conjunction with your case, facts, and evidence. And we're always teaching our investigators to consider and remember the potential impact of such factors as mental capacity, psychological stability, maturity, etc. So when these rules are followed, investigators can be reasonably accurate in their assessment of someone's credibility, but in most, if not all, the research efforts, none of the rules were followed. So the fact that they're no better than flipping a coin, completely understandable. The article goes on to say interrogation is a guilt presumptive process. It's interesting to note that the authors referred to interrogation, specifically the Reid technique, as a guilt presumptive process, meaning investigators interrogate people whom they believe, based on the investigation, are guilty, and they've made a prejudgment of the person's status. Well, it is true that we do interrogate people when the case, facts, evidence, and information indicates their probable involvement. But we're always aware of the possibility someone's caught in a web of circumstantial evidence. We've all seen that over our careers many times. Think about the opposite of interrogating people that the investigation points to. The opposite would be to interrogate everybody, whether there was any evidence implicating them or not, which would be completely unacceptable and unreasonable. The article says that to ensure privacy and control, investigators using the Reid technique are trained to remove suspect from friends, family, and familiar surroundings and question them in a police station, alone, preferably in a small, bare, windowless, soundproof interrogation room, seating in a hardback chair. We do recommend that interviews and interrogations take place in a private setting, but we have never taught any investigators to detain non-custodial suspects or to isolate suspects and prevent them from contacting others. In a custodial interrogation, the subject is advised of their Miranda rights at the outset, and if they invoke any of their rights during the course of the interview, it's over. It's done. We never teach or recommend that the interrogator should try to increase a subject's feeling of despair or hopelessness. In fact, we teach it is improper to tell the subject he is facing inevitable consequences. We reference numerous cases in our book in which threatening inevitable consequences can be a high-risk factor in causing false confessions. It's interesting to note that the United States Supreme Court understands the need for interrogations to be conducted in a private setting. In one of their case decisions, the Supreme Court said, quote, "Often the place of questioning will have to be a police interrogation room because it is important to assure the proper atmosphere of privacy and non-distraction if questioning is to be made productive." We never teach a subject should be seated in a hard-backed chair. In our book, we state, quote, "The chairs, both for the investigator and the subject, should be the type normally used as office equipment. Straight back, as opposed to lounge chairs, of course, should be used for the suspect as well as the investigator. Whenever possible, the seating arrangement should be such that both are on the same eye level. And we recommend that investigators do not use chairs that have lowered front legs or some other deviation that places the suspect in an inferior posture or prevent them in some way from normal changes in posture. The article looks at the length of time associated with appear to be proven false confession cases. In 125 proven false confession cases, they found that 34% were the result of a 6 to 12 hour interrogation, 39% were the result of a 12 to 24 hour interrogation, and that the mean average of false confession cases was 16.3 hours, far in excess of the prevailing norms. There is no doubt that one of the most common circumstances supporting a claim of duress is the length of an interrogation. At what length an interrogation approaches a level of duress associated with involuntary confession is individually defined. But a guideline to follow in regards to is whether or not the interrogators intentionally prolonged the interrogation and kept the suspect isolated in an effort to break his will. And another thing to consider is whether they use a tag team approach, where one investigator, after questioning the suspect for hours, comes out and is relieved by a fresh investigator. Generally speaking, a properly conducted interrogation that lasts 3 to 4 hours for the ordinary suspect is certainly not so long as to cause the levels of emotional or physical distress that would constitute duress. However, if physical coercion was involved, even a 30-minute interrogation may warrant such a bona fide claim. So with the length of interrogation, you have to look at exactly what happened, sequence of events, etc. The article goes on to make the following statement: presentations of false evidence. At times, American police will overcome a suspect's denials by presenting supposedly incontrovertible evidence of guilt. A fingerprint found on the murder weapon, a hair sample, eyewitness identification, a failed polygraph, DNA. Even if that evidence doesn't exist, they'll make it up. In 1969, the United States Supreme Court upheld the use of misrepresenting evidence to the subject. The case was Frazier versus Cupp. In that case, the Supreme Court upheld the admissibility of the defendant's confession, which in part was the result of the police falsely telling the subject his accomplice had confessed. The court held that misrepresentations were relevant, but that they did not make an otherwise voluntary confession inadmissible. In reaching this conclusion, the court judged the materiality of the misrepresentation by viewing the totality of circumstances. It's important to highlight the court's reference to an otherwise voluntary confession, the clear implication being that if the subject's rights were honored, if there were no threats of harm or inevitable consequences, if there were no promises of leniency, and if the investigator followed the guidelines established by the courts, then misrepresenting evidence in and of itself will not jeopardize the admissibility of the confession. This same assessment has been reiterated in several cases and studies. In State v. Colts, the Supreme Court of Vermont upheld the defendant's confession that was made in response to the detective's false claim that there was DNA evidence to prove his guilt. In Commonwealth v. Gillette, the Supreme Court of Massachusetts upheld the admissibility of the defendant's confession, stating, quote, Gillette argues that the interrogating officers misrepresented evidence that strengthened their case and made false assurances that ultimately induced Gillette into making inculpatory statements. We conclude that the officers did not act improperly. In their opinion, the Massachusetts Supreme Court pointed out that we have suppressed defendants' statements in circumstances where police use trickery or a ruse in obtaining a confession. But those cases generally have additional circumstances, apart from the ruse itself, that render the confession involuntary. The court pointed out that these additional circumstances included coercive tactics relating to the defendant's son, minimizing the legal gravity of the alleged crime, suggesting to the defendant that if he did not confess, he would be charged with a more serious crime, and after the defendant invokes his right to counsel, dissuaded the defendant from consulting with a lawyer, and implicitly promised leniency as well as alcohol counseling if he confessed. In other words, it wasn't the misrepresentation of evidence that was the problem, it was the other coercive statements. In State v. Johnson, the Court of Appeals of South Carolina upheld the voluntariness of the defendant's confession, indicating that misrepresenting evidence is not a coercive tactic. Both this court and the United States Supreme Court have recognized that misrepresentation of evidence by police, although a relevant factor, do not render an otherwise voluntary confession inadmissible. The pertinent inquiry is always whether the defendant's will was overborne. Consider the case of U.S. v. Graham, in which the court pointed out that misrepresenting evidence is one factor to consider among the totality of circumstances in determining voluntariness. The court points out that there are a number of cases in which statements elicited from a defendant in response to police deception were found involuntary. But, the court stated, these cases all involve significant aggravating circumstances not present here, such as subjecting the accused to an exhaustively long interrogation, the application of physical force or the threat to do so, or the making of a promise that induces a confession. There's a general consensus of opinion by the courts that lying about evidence in an otherwise voluntary confession will not render a confession inadmissible. However, it is the view of the courts that behaviors such as threats of harm or inevitable consequences, denial of rights, promises of leniency, or other such coercive behaviors will jeopardize the admissible of a subject's confession. According to false confession experts, oftentimes social psychologists, they rely on two sources of research that support their belief that misrepresenting evidence causes false confessions. They say, first, studies of actual cases reveal that false evidence ploy is found in numerous wrongful convictions in the USA, including DNA exonerations. Attorney Garrett looked at the first 250 DNA exoneration cases, 40 of which involved false confessions. And several of those 40 involved subjects who were falsely told evidence implicated them. However, a review of those cases by Leo and Davis reported that many and perhaps most of the interrogations in the cases Garrett reviewed crossed the line of proper interrogation techniques through the use of explicit threats and promises, feeding suspect crime facts, and other coercive practices. In other words, it wasn't the misrepresentation of evidence that was the determining factor, but all of these other inappropriate and improper and coercive behaviors. In another research effort, the author who studied the first 110 DNA exoneration cases reported that this study failed to find a single false confession of a cognitively normal individual that did not include the use of coercive tactics by the interrogator. The author identified coercive interrogation tactics as the use of physical force, denial of food, sleep, or the bathroom, explicit threats of punishment, explicit promises of leniency, and extremely lengthy interrogation. So you're beginning to see a theme here. It isn't the misrepresentation of evidence per se, but when you look at all the other circumstances, the coercive circumstances are what tip the scale. As this research and several of the previously referenced court decisions have found, misrepresenting evidence in an otherwise proper interrogation does not cause innocent people to confess, but the aggravating circumstances within the interrogation, threats, promise of leniency, denial of rights, etc., can create an environment conducive to a coerced and or false statement. According to many social psychologists, there is a second basis for believing that misrepresenting evidence will cause innocent people to confess. And that second source are laboratory experiments that had tested the hypothesis that false evidence leads innocent people to confess they didn't commit. The first of these studies is commonly known as the Alt key. In this study, students were required to perform a data entry project and were warned not to hit the Alt key because if they did, the computer would crash. So when the students were entering their data, the researchers thought the computer would crash and then falsely accused the students of hitting the Alt key and confronted them with a witness who said he or she saw them hit the Alt key. Under that circumstance, a number of students signed written confessions even though they never did hit the Alt key. So that's one of the research studies that they believe convinces them that when somebody's told about false evidence, it will cause them to confess. In a second study, students were given a set of assignments and told that in some assignments, collaboration with a classmate was acceptable, but in others, it was prohibited. The students went through their assignments. The researchers then accused innocent students of improperly collaborating on certain assignments, informed them that they had violated university rules which prohibit cheating, and for some, minimized the extent of wrongdoing and encouraged them to take responsibility for their actions. Half of the students were falsely told that there was a hidden camera in the room which would eventually reveal their guilt or innocence. Under that circumstance, the majority of guilty people who learned about the camera confessed, and half of the innocent suspects who were advised about the camera confessed. but they really didn't confess. When you actually read the fine print in the study, it turned out that the innocent persons didn't confess, but they were asked to sign a statement, a prepared statement that said they improperly collaborated with a colleague, a classmate, but they were reassured that if the hidden camera exonerated them, they would not get into trouble and the statement be ripped up. Well, many of the truthful people signed it because they figured, heck, the camera's going to show I didn't do it. And in fact, there was no camera. In the real world, that'll be like saying to a homicide suspect, look, just write out a statement that you killed the victim, okay? And then if we don't find your DNA at the scene, then we'll rip up the confession and you can go home. Another statement from the article is that, quote, however, purveyors of the Reid technique use minimization tactics in a process known as theme development, through which promises unspoken may well be implied. Typically accompanied by expressions of sympathy and understanding, a detective might provide face-saving excuses and or downplaying the moral seriousness of an offense by suggesting to suspects that their actions were spontaneous, accidental, provoked, peer-pressured, alcohol-induced, or otherwise justifiable by facts outside of the suspect's control. The article talks about 3 studies in which Casson and McNall tested the hypothesis that minimizing would lead people to infer leniency in punishment. And so what they had college students do was read the transcript of a murder suspect. One transcript was edited to produce 3 versions, one in which the detective made a promise of leniency in exchange for the confession, a second in which the detective blamed the victim for provoking the incident, and a third in which neither statement was made. The college students read each version and then estimated the sentence they thought would be imposed. And the subjects who read the minimization transcript where the victim was blamed, they thought that the suspect would face a lesser sentence than in the other cases. Now, even the authors of the study say, quote, because our findings are based on inferences drawn by college students, relatively uninvolved but highly educated observers, it remains to be seen whether similar inferences are drawn by real crime suspects. A number of courts have said the fact that a suspect has engaged in wishful thinking, that if he tells them, quote, he had a good reason for doing it, he'll get less punishment, does not affect the reliability of the statement. The emphasis of the Reid technique is undoubtedly to create an environment that makes it easier for a subject to tell the truth. An essential part of this is to offer the subject a face-saving excuse for the subject's crime, which may include projecting blame away from the subject onto such elements as financial pressures, something the victim did or said to provoke the circumstance, an accomplice, emotions, alcohol, etc. There are 2 types of acceptable minimization: minimizing the moral seriousness of the offense, minimizing the psychological consequences of the behavior. The third type of minimization is to minimize the legal consequences of the subject's behavior, which we teach never to do, because that basically is a promise of leniency. You tell me you confess, you won't spend any time in jail. In the original publication of this article in 2010, the first version, the authors agreed with us, stating that interrogation procedures should, quote, permit moral and psychological forms of minimization, but ban legal minimization. They have now changed their position. Our training is very specific, that excuses, interrogation themes, that the investigator discusses should minimize the moral seriousness of the subject's crime by offering psychological excuses but not removing legal consequences. Consider these statements from our book, Criminal Interrogation and Confessions. During the presentation of any theme based upon the morality factor, caution must be taken to avoid any indication that the minimization of the moral blame will relieve the suspect of criminal responsibility. A second statement. The interrogator must avoid any expressed or intentionally implied statement to the effect that because of the minimized seriousness of the offense, the suspect is to receive a lighter punishment. And a third statement. In applying this technique of condemning the accomplice, The interrogator must proceed cautiously and refrain from making any comments to the effect that the blame cast on an accomplice thereby relieves the suspect of legal responsibility for his part in the commission of the offense. Courts consistently find it acceptable for an investigator to minimize the moral seriousness of psychological. In Commonwealth v. Cartwright, the Massachusetts Supreme Court stated that, quote, "Nor have we concluded that an interviewing officer's efforts to minimize a suspect's moral culpability by, for example, suggesting theories of accident or provocation are inappropriate." The Supreme Court of Canada stated, "There is nothing problematic or objectionable about police when questioning suspects in downplaying or minimize the moral culpability of the alleged criminal activity. I find there was nothing improper in these and other similar transcript examples where the detective minimized the accused's moral responsibility." Gomez v. State, U.S. District Court. Investigators can suggest the defendant may not have been the actual perpetrator or may not have intended a murder victim to die. Suggestions by investigators that killings may have been accidental or resulted from a fit of rage during a drunken blackout fall far short of promises of lenient treatment in exchange for cooperation. In State v. Bologna, the Supreme Court of New Hampshire upheld the admissibility of the defendant's incriminating statements, finding that police can use minimization techniques. In this case, the defendant claimed that the interrogator's minimization of the possible causes of Riley's injuries, Riley is her child, affected the voluntariness of her statements. The court said this interrogation technique does not entail the use of outright falsehoods, but rather the use of subtle subterfuge. Given that police are permitted to mislead a suspect, they are likewise permitted to use minimization techniques. To reiterate, minimizing the moral seriousness of the suspect's behavior or the psychological consequences of their behavior are acceptable techniques. But minimizing the legal consequences of the suspect's behavior or threatening inevitable consequences for a more severe punishment if they don't confess is clearly unacceptable. The article states that John Reid and Associates continue to argue that lying is a necessary evil, effective without risk to innocent suspects. We have published on our website the Reid policy on the use of deception during an interrogation, which includes a number of policy recommendations, including the following. Given current judicial and legislative trends regarding the use of deception during an interrogation, investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. The core principles of the Reid technique are: do not make any promises of leniency, do not threaten the subject with physical harm or inevitable consequences, do not conduct interrogations for an excessively lengthy period of time, do not deny the subject any of their rights, do not deny the subject the opportunity to satisfy their physical needs, withhold information about the details of the crime from the subject so that if they confess, the disclosure of that information can be used to confirm the authenticity of their statement. Exercise special cautions when questioning juveniles or individuals with mental or psychological impairments. Always treat the subject with dignity and respect. The confession is not the end of the investigation. The investigator should investigate the confession details in an effort to establish the authenticity of the subject's statement. One of the videos on our YouTube channel, which is called the Reid Technique Tips, is entitled Best Practices, which I would encourage everyone to review. Thank you very much for taking a few minutes to listen to this presentation.